Good morning, class 8 students. Today we are going to see a new chapter in politics, that is criminal justice system. When we hear about a case of violating a law, we immediately inform the police, and police will make inquiry about the case and they will question some persons, they may arrest. So by seeing all this, we may misunderstand that police is everything. Police is deciding a case, police is settling a case, police is solving all the problems of the society. It is not absolutely true. Police has a particular role. That role we will see in coming section. Before that, in this chapter we are going to see four key players in the criminal justice system. These four key players are: one is police, second one public prosecutor, third one defense lawyer, and the fourth one judge. All these four have great roles in the criminal justice system. First of all, in the textbook, in the chapter, one story is given. You read that story very thoroughly and then you can clearly understand the role of police, role of public prosecutor, and role of defense lawyer, and finally role of judge. We will see one by one all these persons and their roles in the criminal justice system. First of all, let us say about the police. Role of police. The main role of the police is investigation of a case. Investigation of a case. Whatever may be the case, investigating. When the police gets information about the case, police want to investigate about the case. While investigating a case, police want to do collection of statements of witnesses. Witnesses. Who are witnesses? People who have seen a murder or whatever may be the case, whatever may be the incident. People who have seen, they are called witnesses. So police will make inquiry, police will ask questions to them. How have they seen? All these questions and police will write their statements. That is called collection of statements of witnesses. And second one, collection of evidences and material facts about the case. Collection of evidences. These all are part of investigation. The most important duty of the police is investigate a case. While investigating, police want to follow some procedures. These procedures are actually collection of statements of witnesses, collection of evidences and material facts, arrest of accused person. Who are here accused? Accused means suspect, we can say that actually. A person who has committed a crime. Suspect that a person has committed a crime. Suspect is there. This not, police has no right to decide that he is the criminal. He has committed the crime. For that, it is the role of judge. Police is arresting the suspect. That is called accused. And preparation of charge sheet in the court against the suspect. If police is believing that the accused person is guilty and he has committed a crime, police will prepare a charge sheet on him, what crime he has committed and at what time, where, and also who has seen all these details. By citing all these details, police will prepare a charge sheet to the court against him. All these functions police should do. This is role of police. And while investigating a crime, police want to follow a moral code of conduct prepared by Supreme Court. So all the police officers who are making inquiry about the cases should strictly follow the guidelines prepared by Supreme Court. As per the guidelines, while investigating a case or while interrogating, while in detention, police should not torture or beat or shoot any accused while investigating a case. Or police should not misbehave. Police should not give any form of punishment. Also, even in petty or small cases, any form of punishment should not be given. And Article 22 of the Indian Constitution on criminal law guarantee certain fundamental rights to the accused person. Article 22 of the Indian Constitution and the criminal law of India gives or guarantees certain fundamental rights to the accused persons. Let us see what are these. First of all, a right to be informed. Right to be informed means while arresting a person, it is the responsibility of the police to inform him on what charge police is going to arrest him. Police is arresting him. So he has the right to know on what charge, on what case he is arrested by the police. That is called a right to be informed. Second one, a right to be presented before a magistrate. So after arresting a person, it is the responsibility of the police to produce the arrested person before a magistrate within 24 hours of arrest. So police should take the arrested person before the magistrate within 24 hours of the arrest. It is the right of the arrested person. Police should not keep the arrested person in custody without showing in front of magistrate for a long period of time. Police has no right to do like that. And third one, right not to be ill-treated. All the accused persons have the right not to be ill-treated. Police should not behave badly to the accused person. Police can make interrogation, police can question, police can make inquiry, but police has no right to torture or give any kind of punishment to the accused person. Next one, confession. So confession made in police custody should not be seen as evidence against a person, because sometimes police will give beatings, punishments to the accused person, and because of the fear of the police, beatings or brutal cruelties, accused person may accept that he has committed the crime. Such kinds of confessions should not be considered as evidences. And finally, a boy or girl under 15 years of age should not be called to police station for only inquiry, for only questioning. A boy or girl under 15 years of age should not be called to police station for questioning. These should be strictly followed by all the police officers, and these are the rights of accused persons also, or Indian citizens also. So, while investigating a crime or a case, police should collect the statements of witnesses, police should collect evidences, and police should arrest the accused person, police should prepare charge sheet. Now, let us see the topic FIR. What is the full form of FIR? First Information Report. FIR. Let us see what is FIR. It is a written document prepared by the police when they receive information about a cognizable offense. Cognizable offense. What is this cognizable offense? Here, cognizable offenses means offense something serious in the society, like murder, theft, dowry, death, beating. All these can be called as actually cognizable offense. These are very serious crimes in the society. So that means FIR is a written document prepared by the police when they hear or when they receive information about the cognizable offense. And what includes in FIR? It includes time of the offense, time of the crime, at what time the crime happened, or place where this crime happened, date of the crime, time of the crime, and place of the crime. These are three very much important. Name and address of the accused and witnesses also should be highlighted. Name and address of the witnesses. And we know that actually details of the facts of the offense that also should be included. All these are, we can say, together FIR. It is prepared by police. That means when they receive an information about a cognizable offense. And this FIR, police will submit to the court also. The FIR can be called as charge sheet also. FIR can be called as charge sheet also to the police, and it will be handed over to the court. FIR. Now let us see the role of public prosecutor, role of defense lawyer, role of judge, and finally, what is fair trial? First of all, let us see role of public prosecutor. Public prosecutor is the agent of the state. Public prosecutor is a lawyer who represents the interest of the state. We know that actually every criminal offense is a public wrong. It is not only affecting the person who suffered that crime. It is affecting the entire society as a whole. So, to protect the interest of the society, to protect the interest of the state, one lawyer is there in the court. That lawyer is called public prosecutor. As the agent of the state, his or her duty is to act impartially and to produce evidences, material facts, and also witnesses in the court and help the court to decide the case properly. That is the role of public prosecutor. And now let us see here defense lawyer. As per the Article 22 of the Indian Constitution, all the Indian people will have a right to defend his or her case by appointing an advocate. And Article 39A states that if the accused person is not able to appoint an advocate because of the lack of money or any other problems, the state government should arrange an advocate for defending the case of accused. So we know that actually defense lawyer. Defending is the right of accused person. As per Article 22 of the Indian Constitution, any accused person of India will have a right to appoint an advocate to defend his case. And as per Article 39A of the Indian Constitution, all accused person will have, as per Article 39A of the Indian Constitution, government should arrange an advocate for accused person if the accused person is not able to appoint an advocate because of the lack of money or any other problems. Because defense lawyer should be there and a proper public prosecutor should be there. Then only proper arguments will be there. Then only the court can clearly understand who is right and who is wrong. Which side is right, which side is wrong. The defense lawyer is trying to prove in the court that his client or accused person is innocent by pointing or by informing the court, by showing the court the evidences, witnesses, material facts. By all these, he is arguing in the court that his client or accused person is innocent. His main duty is to show or prove in the court that his client or accused person is innocent. But public prosecutor is trying to collect evidences against the accused. Public prosecutor is trying to get witnesses against the accused. Public prosecutor is studying deeply the cases and he is trying to show, he wanted to collect evidences in a proper way without any malpractices, and he need to try to help the court to decide the case, public prosecutor. Now let's see the role of judge. By understanding the arguments of both public prosecutor and defense lawyer, and by understanding the evidences presented in the court by public prosecutor and defense lawyer, by understanding the witnesses, material facts presented in the court by the public prosecutor and defense lawyer, the role of judge is to decide the case, whether the accused person is committed a crime or not, he is guilty or not. If the defense lawyer is able to prove in the court by showing evidences, material facts and witnesses that his client or the accused person is innocent, the judge will decide the case in favor of accused, and the judge will the judge will make a judgment to release the accused from police custody. But if the public prosecutor is able to prove by showing material facts, evidences and witnesses in the court that the accused person has committed a crime, the court will make a judgment, especially the judge will make a judgment against the accused, and the judge will decide the punishments. This is the role of judge. So we have seen public prosecutor, defense lawyer and judge. And now let's see fair trial. Fair trial means an impartial trial. A quality trial for both accused and also for the complainant. trial should be arranged in open court. There, the accused person should be able to see the trial or understand the trial in front of the accused. Trial should be arranged. And here, the people who gathered in the court should be able to see the trial. And if the accused is able to get a copy of charge sheet, that is also the part of fair trial. And if the judge is making the judgment on the basis of the arguments made by public prosecutor and defense lawyer, and on the basis of the evidences, material facts and witnesses presented in the court, that is also called fair trial. If all these are not done properly, that is cannot be called a fair trial. That is only in this chapter. It is a very easy chapter. We know criminal justice system, the role of police, role of public prosecutor, role of defense lawyer and judge. So it is the duty of the police only the investigation. So public prosecutor is not the person to investigate a case. A defense lawyer, the judge is not the person to investigate a case. Investigation must be done by police. A case want to be settled by judge. It is not the duty of police. It is not the duty of defense lawyer or public prosecutor. The role of public prosecutor is to prove that the accused person is guilty by appointing evidences, material facts and witnesses against him in the court. And the defense lawyer, the duty and responsibility of the defense lawyer is to prove that his client or the accused person is innocent. He needs to show some evidences, material facts and witnesses in the court and ask the judge to release his person on the basis of all these. This much only we need to study from this chapter.